Hello, I'm attorney Gary Finklea from the Finklea Law Firm in Florence, South Carolina. Today I wish to share with you the various fee arrangements you can make with a lawyer. Now generally there's three types of fee arrangements. One is a fee arrangement based upon an hourly basis. Another is a fee arrangement based upon a flat fee. And the third is a contingent fee. First, let me state that all fee agreements should be in writing and should outline the lawyer's fee agreement, what the lawyer expects to get paid and what the client should expect to pay and when and how. Now first let me discuss with you a contingent fee arrangement. A contingent fee is a fee that is a contingent upon the outcome of the case. If the lawyer does not win, there is no fee. Generally you find contingent fees anywhere up to 40% of the recovery. In South Carolina, generally the recovery includes the total settlement or verdict obtained. We have some clients to ask, well, is that contingent fee after medical bills are paid? No, that contingent fee is off of the top of any recovery. Now at our law firm, what we generally try to do, of course, is to reduce our fees if necessary so the client always nets more, certainly not less than the lawyer, because it's of course the client's case. But contingent fees is one type of ways that we take a case. That agreement must be in writing. It's required to be in writing under our ethical rules. Now in addition to the lawyer's fees, and this is the case in any type of fee arrangement, there are costs involved. Costs are generally separate and distinct from fees. Costs include not only checks that we write to third parties, like for filing fees, service of process fees, publication fees, mediation fees, witness fees, subpoena fees, fees for medical records and things like that, but also can even include copy fees, fax fees, postage, and things of those sorts, sort of in-house fees that we have. So the first type is contingent. Another type is a flat fee arrangement. That is where you contract with the lawyer. The lawyer agrees to provide a service to you or representation in a case regardless of how short or long it is for a flat fee. Generally we find flat fees in criminal cases. Also find them in immigration cases. Sometimes even in simple divorce cases you find flat fee agreements. Again, with those agreements, be careful that, or at least understand whether or not that flat fee includes not only fees but costs as well. I would say generally costs are on top or in addition to the flat fee. And the last way that lawyers take cases is on an hourly basis. The lawyer keeps track of his time and will bill the client every month or two to get paid. Generally when lawyers take cases on an hourly basis, they bill not only for their time but for their legal assistant time, and then on top of that you will have costs that lawyer paid as well. Again, read your legal retainer agreement to understand how those fees will be billed and how you're supposed to pay them. In our office we keep detailed time records, and we hope they're detailed at least, and send you a detailed bill at the end of each month. We just don't send you a bill on a certain date or reflecting we did a half-hour work on your case on a particular date. We give you detailed description on what we do. I know some lawyers that send clients bills for hourly work and don't give any description. They just put, we worked 2.5 hours on your case this month without any description or any idea of what the work was done. So the more detailed you are, the better it is for everyone. Generally we find hourly cases in domestic cases and in litigation cases, in civil litigation cases where contingency fees aren't appropriate. So generally in all litigation cases, civil litigation cases, except when you take the case on the contingent fee basis, will be taken on an hourly basis. And then of course you can have all sorts of fee agreements in between those two hybrid arrangements. Sometimes in consumer cases we take them, if you pay a flat fee and we reduce our contingent rate, so for example we'll charge a $500 flat fee and then do a retainer as well, or a contingent fee. So we do a hybrid arrangement. And let me point out too, another aspect of fees is a deposit and a retainer. Oftentimes they're confused. In my opinion, and what I believe the industry standard is a deposit is basically what it says. It's a deposit on which future fees can be billed against. A retainer, however, is a fee that you pay just for doing business with the lawyer. For example, if you come and solicit us to represent you on a domestic case, we might charge you a $500 retainer and a $1,500 deposit. What that means is you give us $2,000. The $500 is earned immediately because it's a retainer. It's the price you pay in just to do business with us. And then the $1,500 is placed in an escrow account, and we bill our future time against it. So be sure when you ask about deposits and retainers, you get a clear understanding with your lawyer on what those mean. So if you have any questions regarding fee agreements, of course you should first contact the lawyer you're dealing with, but if we can be of assistance, please contact us at the Finklea Law Firm at 843-317-4900, or you can reach me by email at gfinklea@finkleylaw.com. Thank you very much. Have a great day.